Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hi everyone.
Now, in a week where tax has dominated the headlines, there seems to be a number of about turns where the government is concerned. The proposed reform of judicial review has been rumbling on for some time now. Dennis, what do you know about the government's second thoughts on this?
Well, Helen, it does look like a government U-turn. This was always a rocky road culminating in numerous House of Lords amendments that the government couldn't turn back. Here's the story. The government has now signalled that it will drop further reform of judicial review from its legislative programme after suffering 3 narrow but significant defeats in the House of Lords last week. Peers have voted to remove a number of flagship proposals from the Judicial Review and Courts Bill. The House of Lords also passed an amendment which would limit the abolition of the so-called court jurisdiction, by which a party can bring a judicial review in the High Court when an application for permission to appeal has been refused by the upper tribunal. Now, the 3 amendments are likely to be reversed, of course, when the bill returns to the House of Commons later this month. But they have already done damage to the government's plans. The heated controversy surrounding the bill appears to have prompted the government into dropping other radical legislation as well. A Sunday Times article, quoting Whitehall sources, said that next month's Queen's speech will confirm that legislation on rights to challenge government policy in court is no longer on the timetable. The Sunday Times reports that the reforms dropped from the Queen's speech are those that particularly divide Tory opinion, and the most significant U-turn is expected to be on planning reform. There is a central theme to the government's motivation behind these reforms. The government really is obsessed with getting its own way, whether in court or in Parliament. Judicial review, of course, enables claims to be heard that shine a light upon the legality, or should I say illegality, of how government conducts itself, whether it's attempting to prorogue Parliament, they lost that one, the unlawfulness of their pandemic procurement decisions to buy PPE, they lost all of those, or appointing staff to senior government positions without any means of assessment, they lost that one too. And then, of course, there was the ethics debacle over the case of Owen Paterson, where government adopted a similar attitude, and the usual U-turn followed. And of course, there'll be more like this.
Well, in other news, the family court statistics for October to December 21 have been published by the Ministry of Justice, which show that the average time for a care or supervision case to reach first disposal throughout 2021 was 45 weeks, which is up 6 weeks from 2020. The statistics show that the average time for the final 3 months of 21 was higher still at 47 weeks, up 5 weeks from the same quarter in 2020. There were 6,933 individual children involved in new public law applications in October to December, down 6% on the same quarter in the previous year, while the number of applications made decreased by 9%. The number of public law disposal events decreased by 21% over the same period. The statistics showed an increase in both applications and orders made in relation to deprivation of liberty. There were 1,687 applications relating to deprivation of liberty made in the most recent quarter, which is an increase of 24% on the number made in 2020. And whilst an increase in applications for orders under the Mental Capacity Act was seen, the number of orders actually granted decreased. Since the Supreme Court clarified the definition of deprivation of liberty in 2014, there have been a significant increase in the number of applications over the following years. There were just 109 in 2013, rising to an all-time high of 6,286 in 2021. Now back to the government's decision-making. What's the latest on the rumours concerning the removal of contentious proposals in the planning white paper, Dennis?
Helen, I'm not entirely sure yet, but they may be clinging on to their reform of Section 106 agreements. Here's the latest. You may have heard reports that the government is also having second thoughts on some aspects of its planning reforms. but not, it seems, concerning the abolition of Section 106 agreements in their current form. The government has confirmed that it is still considering introducing a controversial new infrastructure levy, partly to replace Section 106 agreements. In a response to a House of Lords Built Environment Committee on Housing Delivery, the government said at the end of last month that it is still exploring the introduction of a new infrastructure levy which will replace Section 106 planning obligations and also the existing community infrastructure levy. The levy was first proposed in 2020 as part of the government's planning white paper, which has been on the back burner since Michael Gove took over as Housing Secretary, and his department was rebranded to focus on levelling up. However, despite a wholesale shake-up of the planning system now appearing to be off the table under Mr. Gove, it appears that the proposed levy could remain. In its response to the House of Lords Built Environment Committee report, which was published in January, the government said it was considering the details of a new levy that would reduce complexity and uncertainty and enhance the transparency of developer contributions. Now take a look at the interesting LGL article posted in the latest bulletin on the impact of these proposals upon the subject of affordable housing provision.
Well, I certainly will do that. Now, taken from the LGA's briefing, the Secretary of State for Education, Nadhim Zahawi, published the government's Green Paper for improving outcomes for children and young people with special educational needs and disabilities and those in alternative provision. The consultation sets out proposed reforms that seek to address three key challenges. These are improving poor outcomes for children and young people with SEND or in alternative provision, helping them navigate the SEND system and alternative provision, and delivering value for money for children, young people and families. In a statement to the House of Commons, the Secretary of State said that the current system had become financially unsustainable, with councils in deficit and overspending on their dedicated schools grant. The Secretary of State also published a schools white paper, which sets out the government's ambition for a school system that helps children fulfil their potential. The white paper also looks to define the roles and responsibilities of all those involved in the system, including the role of councils, and sets out how they plan to ensure councils have the right powers to deliver in their role at the heart of the new system. In his statement to the Commons, the Secretary of State said councils would be given powers to set up their own multi-academy trusts. The issue of ghost children not in schools was also raised, and the LGA noted that the government intends to bring forward legislation that will create a register of homeschooled children, which it has long called for. Now, Dennis, during the pandemic, you've covered the changes to office working practices, and I see that there's a new survey which sheds some light on the current situation. What's the headlines?
Well, Helen, there are no real surprises here. Hybrid working is here to stay, but it does raise questions about the need for managers to adapt to the new working environment. Here's my report. 2 years on from the imposition of remote working as a result of the COVID-19 pandemic, the majority of local government lawyers and heads of legal are set to continue working from home for most of the week. This is the headline revealed by new research by the local government lawyer in association with LexisNexis. The Life After Lockdown report also found that the job market has been energized by the expansion of remote working opportunities, with 1/5 of lawyers surveyed reporting that they had changed jobs during the COVID-19 crisis. Of those heads of legal surveyed at councils that have decided upon the future of remote working, 31% reported that their local authority would require people in the office for 2 days per week. 13% of managers surveyed said their staff would be working 1 day a week in the office. Despite widespread support for remote working amongst lawyers, the survey also found that 16% of lawyers reported isolation and poor motivation as the biggest problem when working from home, making isolation and poor motivation the biggest issues flagged by respondents. The research found that managers are also experiencing problems maintaining morale. Heads of legal said it was the single biggest problem they faced, with over half reporting difficulties. Now, this survey reflects the results of our own research and reporting during the pandemic. Managers really do need to react and respond effectively to the challenges of hybrid working and put the maintenance of staff well-being at the top of their task list. There's much more in this survey, and members should take a close look at the trends that are now emerging in our sector.
Well, wellbeing, of course, is at the heart of the Health and Care Bill, which has been subject to quite a few Lords amendments, sent back to the House of Commons and back again to the House of Lords. It's officially in a state of ping pong, which literally is the correct word to use in these circumstances for those of you who may be unaware. The Elections Bill is also in the House of Lords, but not nearly earning as much coverage as the other more prominent bills in the press, despite its importance. LLG will, of course, report on these matters as they progress. Now, LLG held its AGM last week and are delighted to announce Helen Edwards as the new LLG president, succeeding Quentin Baker as the outgoing president. Looking ahead to her presidential year, Helen set out her ambition for LLG over the next year, stating, "One of the key themes I would like to focus on in my presidential year is the opening up of access to the legal profession, to really champion equality, diversity, inclusion, and social mobility. We will work with other stakeholders to enable the start of what I hope will become a legacy of supporting individuals from all backgrounds to forge a successful career in law." We also saw a number of new appointments to the board, 5 in total, and said goodbye to 6 others, to whom we give grateful thanks for their long service and dedication over the years. They are indeed worthy of naming here, and it was a privilege to work with them on the board of LLG. They are Philip Horsfield, Stephen Taylor, Stephen Turner, Sarah Duxbury, Sabina Bai, and Nigel Snape. We will be looking forward to welcoming Helen Edwards to the podcast very soon in a special guest appearance. But until then, that's it for another edition of the podcast. You can read more on our AGM, the items discussed today, and many more besides by going to bulletin number 14, available on the LLG website now. We're taking a well-earned break over Easter, but we'll be back on the 25th with all your essential catch-up news. So until then, it's goodbye from me.
And from me too.
Thank you for listening. Enjoy all that lovely chocolate and have a good week.